Good afternoon, ladies and gentlemen. Welcome to today's program, the Uniform Child Abduction Prevention Act, should New York enact it. Today's program is sponsored by the Family Law Committee of the New York State Bar Association's International Section and co-sponsored by NYSBA's Family Law Section. For your questions, you may pose them using the Q&A function below your Zoom portal. And just a reminder, this webinar does not carry any MCLE credit. To begin today's program, help me welcome the co-chairs of the International Section's Family Law Committee and today's moderators, Ms. Melissa Kuczynski and Mr. Richard Min.
Hi, it's really nice to have everyone here join us today. I'm Melissa and Richard is also on the Zoom. We are the co-chairs of the committee that Kara just introduced to you, and we're really grateful you're here. Today's topic relates to the Uniform Child Abduction Prevention Act. It is a uniform law that was put forth by the Uniform Law Commission. I believe it was in 2006. We're here to learn a bit more about it today and learn more about the Uniform Law Commission. We have some amazing people here today that we're going to introduce you to before as we're getting started. And the goal that Richard and I can help you elaborate more is that we're trying to introduce this act and see if it is an act that the New York legislature should enact in the state of New York. And so we encourage everyone to submit questions, ask our panelists questions about the act so that you can determine whether or not that you want to be involved in helping pursue enactment of this particular act. Richard?
Thanks, Melissa. And if any of you are members of NYSBA or members of a particular section or committee and you want to help us promote this legislation, please contact us after the program and we can help you get in contact with the right people so that your section or committee could help promote this act. We do think it's very valuable, of course, otherwise we wouldn't be putting on this program. It's something that has been enacted in several other states. And as we'll discuss in this program, works in conjunction with existing legislation to help, prevent child abduction, which continues to grow year by year. And if anyone is interested in joining our section and our committee, New York State Bar Association International Section Family Law Committee is what Melissa and I co-chair. And this is the second program we've put on since we became co-chairs a couple months ago. And we have a couple more programs in line, I think another one in a couple of weeks on French and US prenuptial agreements, and then another one early next year, hopefully, that we're keeping a surprise.
So why don't, to get started, I can call on our folks who are here on your screen just to say what their name is and give a little detail about what role they've had when it came to creating UCAPA. So I'm going to start with Linda Elrod, who is right there in your screen with the beautiful sun, the sky behind her. So Linda, could you introduce yourself and tell us your role in UCAPA?
Sure. My name's Linda Elrod. I'm a professor at Washburn University School of Law, and I was the reporter for UCAPA, which basically means draft, or not the policymaker, but the drafter.
Wonderful. And Lyle Hilliard.
Thank you. My name is Lyle Hilliard. I'm a longtime, now former state senator in Utah. I've been involved with the Uniform Law Commission for well over 20 years. I'm what's called a life member. I was the chairman of the drafting committee that took the time to take the input and study and draft this bill. So I'm really quite familiar with that. But personally, I've been involved as a lawyer on several of these cases, and they're heart-wrenching. When somebody takes a child and suddenly you can't find the child, and next thing you know, the child's in a foreign country. And you had some warning that may have happened, but you feel so helpless when that occurs. So I've appreciated working, and especially with Linda Elrod. She really has been a great support and great work on it, understanding this issue. But we're glad that some states have adopted it, because when you need it, it needs to be there.
Fantastic. Lindsey Beaver.
Thanks, Melissa. Hi, everyone. I'm Lindsey Beaver. I'm an attorney at the Uniform Law Commission at our headquarters here in Chicago. I've spent 7-8 years working on our portfolio of family law acts, and my colleague Libby Snyder, who will introduce herself in a minute, will be taking over that portfolio. But this is, a really important act in the Family Law Act. It's something that has been enacted in 15 states, and I know of 2 states that are actively considering it for this for an upcoming session, and that's not counting New York. So we're very interested in providing whatever information we can to folks interested in possibly pursuing an introduction of the act.
Fantastic. Thank you. And Libby.
Thank you, Melissa. My name is Libby Snyder. Like Lindsay mentioned, I'm another attorney at the Uniform Law Commission located at our headquarters in Chicago. I am learning from Lindsay right now and will be transitioning to take over the Family Law Act portfolio. I'm very excited. These are all acts that really interest me. This has been a subject matter area that I've been interested in for a long time, and I'm excited to get to work on these acts with Linda and with Lyle and with Melissa on a few other acts as well. And so thank you for having me here, and I think we have a great presentation for y'all.
So before we get into the guts of UCAPA, Richard and I thought it might be helpful for us to ask some questions about the Uniform Law Commission first and foremost, because if none of you are familiar with it, it is definitely an organization with which you should become familiar before you even dive into what their acts are. And any family lawyer likely knows or is familiar with some of their acts, which I know Linda was planning on talking about: the UCCJEA, there is UIFSA. So this is just another one of those acts. So I'm going to toss out a question, and I'm not sure who wants to jump in, maybe one of the legislative counsel for ULC, but what is the Uniform Law Commission?
I can answer that, Melissa. So the Uniform Law Commission is an organization that's been contributing to law reform in this country for about 130 years. We provide states with nonpartisan legislation that's designed to add stability to and clarity to statutory law. Our commission is composed of commissioners who have to all be attorneys qualified to practice law. They tend to be legislators, judges, law professors, professional legislative staff, and all of our commissioners are appointed by state government, either by the governor or their legislature. And we have over 400 uniform acts, and we draft in all areas of the law, including, family law, but also trust and estates, real property, emerging technologies, commercial law. I think one of our most famous series of acts is the Uniform Commercial Code. Anatomical Gift Act is another act that I think has been almost universally adopted, that a lot of people know, but we also have many, many family law acts. And we'll touch on, it sounds like we're going to touch on a few of those today, including the Child Abduction Prevention Act. And I'll stop there in case someone has anything else to add.
Yeah, this is Lyle Hilliard. I'd like to add a perspective non-staff. Excuse me. I'm a commissioner. I was appointed by Governor Leavitt, and at the time I was the majority leader of the Utah State Senate, and went to the meetings. And the meetings really are interesting because they have a week-long annual meeting where every one of these acts are read line by line by the drafters on the drafting committee to the whole body of attorneys. There's probably 300 to 350 attorneys. Every state is represented. Utah has 6 commissioners, and each state's about like that. And we end up then debating and talking, and each attorney has the ability to ask questions. My first meeting, I thought I was going to go crazy with all the attorneys and all the questions, but it really is a pretty thorough process. We draft bills like this when someone makes a recommendation to the conference that this is an area that would be good for a uniform law. As a state legislator, I like it because we have our input, and as it's presented to the state of Utah, our people can look at it and see if it applies, can make some minor changes to it. Every change we make, I clear with with staff in Chicago to make sure it still keeps uniform. But the advantage is that as it goes along as a year and we get experience, I can even go back to Chicago and say, we don't like this phrase in it. We found better language and amend it as we go. Our real thrust is we do not want federal legislation to supersede us, because that's one size fits all and you have to live with what they finally have done. So it's really an answer to give more local control. I was assigned as chair of this drafting committee, and in it were appointed about, I'm going to guess, 10 to 15 lawyers from the conference, all commissioners. Some had experience in family law and some had none. And we hired a law professor, Linda Elrod, who was an expert in family law provisions. And she actually did the drafting for us, made presentation of ideas, and we'd have a drafting meeting. We did 2 of them a year, one in the fall, one in the spring. We would start on a Friday and go Friday, Saturday, and sometimes even into Sunday. And these are really pretty intense drafting meetings. We invite a whole number of different groups who may have interest in the act to send observers. And it's not uncommon in these acts to have 30 or 40 people there who come with different ideas and different perspectives they represent. So we think that by the time we get the act done and approved by the conference and submitted to the people, it's also approved by the ABA winter meeting. They approve it as well. But we have a pretty thoughtful act that's been presented in a way that has a lot of eyes looked at it, a lot of drafting. We appreciate very much the legal staff we have at the conference who help us, like Lindsey. But again, I came to a great appreciation of Linda Elrod. She was really a great worker and really had great insight as we debated as a drafting committee what to include, how to word it, concerns that we ought to be aware of, and then to go through the scrutiny. It was read twice to the conference, and again, 300 lawyers looking at it, wondering about every word and every phrase and how we did it. So it ended up, I think, a pretty thorough. There was some controversy about it, and we understand that every time we deal in family law, you have to be concerned because there are people who are impacted who may feel that it's unfair to them. But I think this is a pretty well-balanced act and is addressing an issue that I personally have found as a lawyer in a small town where I've got a university and we have quite a few international students who come and end up with situations where they end up parents of a child, and then the issue is, does the child go back to Mexico or China or to Iran or wherever the country may be, with one spouse being American. So it ends up in a way, I think, that we can level it out. So that's the background, I think, for people to understand. The uniform law, I know when I present bills at the Utah legislature, over the years, they've come to appreciate the thoroughness in which we do the work. So they're usually fairly easy to get past because the people know that a lot of their questions have been answered. Thank you.
So, Richard, do you have any questions of our panelists before we get into the guts of the act?
Yes, and just quickly, I wanted to ask Libby and Lindsey, you had mentioned that there was a family law portfolio that you manage, and I wanted to know what that family law portfolio consisted of. What other family law acts have been passed over there?
Sure, I'll start and Lindsey can fill in around the edges. I think that the all-star of the portfolio, the one that everyone knows, is the Uniform Child Custody Jurisdiction Enforcement Act, the UCCJEA. I think that's been enacted in most states, 47, 48, something
49.
like that. 49, thank you,
Yes,
Linda.
and the territories.
We also have the Uniform Parentage Act, which was most recently revised in 2017, the Non-Parent Custody and Visitation Act, Child Abduction Prevention. We have 2 new acts that went final this past year, the Uniform Unregulated Child Custody Transfer Act and the Uniform Cohabitants Economic Remedies Act. Which ones am I forgetting, Lindsey? I know there's several more.
A couple more that may be of interest in New York. So the Recognition and Enforcement of Canadian Domestic Violence Protection Orders is another really good act that has family law, international law implications. So this group might be interested in that act. And let's see, I don't believe New York has the Uniform Deployed Parents.
Yeah.
Yeah, that's another one that may be relevant to this group.
And another one that Linda Elrod served as reporter on, the Family Law Arbitration Act.
Okay, so I think we're going to get into what UCAPA entails. So Linda, did you want to try to share your PowerPoint?
I'm going to try.
You're going to try.
Did I do it?
Yes, perfect.
I did. Miracles happen.
And Linda,
okay.
before you start, I just want to encourage everyone who's participating to ask questions. Melissa and I do like to encourage participation and active participation. So, if you have questions, there's a chat function on the bottom, a Q&A function. You can hit on that, and Melissa and I will, interrupt and ask questions along the way.
Okay, you ready? Ready for me to go? Okay. The Uniform Child Abduction Prevention Act, UCAPA, we call it because it's easy, came about because of a lot of things that happened in the 80s and 90s, including a lot of abduction of children. But part of it was also, there were some federal grants to do studies of how many kids were abducted. And so we actually had raw data that we hadn't had, and we actually haven't had since in as good a form as we had back in that time period. But basically what they discovered is that most children who were abducted by a family member. We put a lot of emphasis on stranger abductions and kids not talking to strangers, but it's parents that are taking their kids more often than stranger abductions. And we had the benefit of some study.
It off makes me look big.
Lyle, you might want to mute. Okay. We had some studies done by Linda Girdner and Janet Johnston. Many of you may be familiar with Janet Johnston, who has done a lot of work on high conflict custody cases. She and Linda Girdner had a grant, and they did extensive research on, can you figure out who's going to abduct? Are there common characteristics? So she came out, the two of them came out with risk factors for abduction based on huge sample of cases. In addition, Pat Hoff, many of you are familiar, she was one of the prime proponents of the Uniform Child Custody Jurisdiction and Enforcement Act, and went around training law enforcement on the enforcement provisions, and has done a lot of research and work and talking in the area. The Polly Klaas Foundation started and had a publication in 2004, and then the National Center for Missing and Exploited Children started doing work. So there were a bunch of things that came together that said maybe the time is ripe for a uniform law dealing with how do we keep parents from abducting their children. And one of the problems that we discovered right off is that the remedies we had were inadequate. There were some custodial interference statutes, but they only did any good if you could find the person interfering. And you may remember the Colorado case where I think grandmother and somebody else took the kid and went out of the country, and they never got him back. They charged him and everything, but never got him back. Tort remedies, again, insufficient. If you can't find them, can't collect, you want your child, not money in most cases. And enforcement mechanisms like contempt and fines and money weren't working either. So NCUSL has a history and a background dealing with trying to deter abductions. If you read the preambles in the beginning of the Uniform Child Custody Jurisdiction Act, which was the 1968 and the first act that was put out, the idea is maybe if we could just agree which state should have jurisdiction, then people would quit fighting and we would quit forum shopping back and forth at the end of visitation periods. The problem with the UCCJA that became apparent very quickly was there were co-equal bases for jurisdiction, 4 bases, they were co-equal, no priority given. The PKPA, which was federal legislation, came about to try and prevent what was going on with UCCJA, and it prioritized home state jurisdiction and introduced the concept of continuing exclusive jurisdiction. In addition to the PKPA, Congress passed the International Parental Kidnapping Crime Act, but it was only for international and not for intrastate. There were also some immigration sanctions, and there was the creation of the Passport Alert Program. So all of this is kind of coming around the same time. So 1997, NYSBA starts drafting the Uniform Child Custody Jurisdiction and Enforcement Act. What it did was copy the PKPA, because the PKPA, as federal legislation said, one state only has to give full faith and credit to a custody order from another state if it's made in accordance with the provisions of the PKPA, which prioritized home state jurisdiction and contained continuing exclusive jurisdiction. That's exactly what the Uniform Law Commission did. They basically took the PKPA and put it into a uniform law for states to adopt. It changed emergency jurisdiction from a co-equal basis to being temporary emergency jurisdiction under a separate heading. It added continuing exclusive jurisdiction, and it added enforcement mechanisms, including a turbo warrant, which was a really quick warrant to get a kid back if you had a court order. However, there were still problems. The UCCJEA doesn't say what should be in a custody order. And what we discovered is that many of the custody orders that led to abduction, where lawyers put into agreements reasonable visitation, reasonable times upon consent of the parents. Well, what we found is what's reasonable to one parent isn't reasonable to another if it's a high conflict case. And if you're asking a policeman to enforce, or a policewoman to enforce a custody order, they're not going to enforce reasonable because they don't know what reasonable is either. And so one of the things that needs to happen if we're going to make sure kids don't get abducted is that we have to have specific time periods for visitation set out. Good parents will loosen up and do what they can, but if you want to enforce it, you need specifics. Emergency jurisdiction only listed abandonment and imminent abuse. It did not list abduction as an emergency factor. So that left that open there. And it's only if you can equate abduction with child abuse, which several authors have, that you could use the UCCJEA with an abduction. There were some questions as to whether there was intrastate enforcement, like in a given state, if in fact it could be used, if UCCJEA could be used. It was clear interstate, but not intrastate. And the enforcement mechanisms of UCCJEA only work if you have a custody order in place, not pre-decree. Now, the other thing that was out there is the Hague Convention for international cases. The Hague Abduction Convention, one of 5 family conventions, helps secure the return of wrongfully removed or retained children. It does not prevent the abduction. So the Hague isn't a complete remedy because it doesn't prevent someone from taking the child. It just gives you a tool to try and get the child back. However, there are defenses that may prevent return of the child, especially if you file it after 1 year. Not all countries are parties. At the time we started drafting, there were only 60 parties to the Hague Abduction Convention. Today, there are 101, I believe, parties to the Abduction Convention. But even if the country is a party, we have several countries that are not compliant. And what I mean by that is they've enacted the convention, but they don't send kids back, which is a problem, if that's what you want. So our original charge was to draft standards for protection of children from international child abduction. At the very first meeting that Lyle headed, we started talking about it. Every abduction starts out as a domestic abduction. They're taking them from a state to an airport in your state or a neighboring state and flying overseas, maybe stopping in the States a couple times on the way. But we decided that an act that was going to prevent child abduction had to apply to domestic as well as to international abductions. And so that was the first thing we did, was expand the scope. The distances across the state of Texas, Montana, California, they're as big as going to Mexico from Arizona or any place that may be inter-country. California's statute covers both domestic and international abductions. So we enlarged the scope of the act to include both pre-decree and post-decree child abduction. And that's a significant benefit to this act, because most parents have joint custody of children naturally by operation of law, even if there's no court order. And so being able to have a parent be able to go into court and ask for an order to give them a remedy to prevent abduction before getting the court decree can be significant. It's premised on preventing child abduction is in the child's best interest. There was research at the time from Grief and 3 other people and Marilyn Freeman documenting the harm to children. Marilyn Freeman, who is an English researcher, and Nicola Taylor from New Zealand published a fairly large article, 2016 and I think 2018, documenting harm to children. They interviewed children from all over the world who had been abducted. And it is harmful to children to be abducted. It is a long-term, long-lasting, life-changing harm. So preventing abduction is important. The one thing to know about UCAPA as we're going through it is it's civil law. It is not criminal law at all. It is civil. It complements and supplements existing law. It in no way interferes with UCCJEA. It does not interfere with existing state remedies for custodial interference with child support. It's like a 4th article to the UCCJEA. In fact, Pat Hoff, who wasn't an observer at our meetings, Pat Hoff said, we should have thought of this. We should have included abandonment as a 3rd emergency factor when we were writing the UCCJEA. We just didn't think about it. And part of it was the timing, part of it was they were looking at other things. So what this really does is add threat of child abduction as a 3rd basis for emergency jurisdiction under the UCCJEA. The definitions track both the Hague Convention, Abduction Convention, and the UCCJEA. So the learning curve should not be great for anyone adopting this, because you already have the terminology from UCCJEA and from the Hague Abduction Convention.
Linda, can I stop you here and ask you a couple of questions?
Maybe.
Okay. Well, I'll ask them and then we'll see if you want to answer them. So I'm curious, just in the world of child abductions, how the interplay between UCAPA, the Hague Convention, and UCCJEA works in real life terms or real world terms. So, oftentimes in a Hague Convention case, a child is abducted to the United States from a foreign country, and the passports are turned over, temporary orders are issued because there's a fear of further abduction. Is that a ground for a court to take temporary emergency jurisdiction under UCAPA?
Yeah, I would think so. I mean, you will see when we get to the basis there, it says any other basis under state law. And so that would be broad enough to cover that circumstance. It is not listed as a specific, but it would be broad enough under the catch-all provision.
And have you ever seen a child be returned under the guise of UCAPA instead of the Hague Convention or UCCJA? Would that be
Well,
something that
what-
the commission considered?
Yes and no. Let me give you an example. We have it in Kansas. We adopted the UCAPA, and it was used in a case about 2 years ago. And I have a copy of the petition if anybody wants a copy of it. But basically, it was an unwed couple. They had lived together. There was no question about parentage. The mother decided she was going to go to North Carolina. She told the boyfriend she wasn't going to return, that she was going to stay there. She wasn't coming back to Kansas. He filed both under UCCJEA, and he filed a UCAPA for prevention, orders to keep her from taking the child without prevention orders in place. And it worked. And the judge in, I think it was North Carolina, sent the kid back. So it does work. You just have to make your allegations and proof, and I'll talk about that when we get to specifics.
Okay, and I'm assuming we'll get to, I guess, the measures that are available to the court. In order
Oh, yeah.
to
Yep.
preventive measures. Okay, and I'll save
Yep.
some of my questions till then.
Okay, yeah.
Perfect.
Hold. Now, what does UCAPA do? It gives tools to judges to make orders clearer. So if the lawyers haven't done their job of making clear orders, merely filing an action under UCAPA, even if the court doesn't order anything else, the court can clarify the orders. And we'll talk about what that means later. It applies to intrastate as well as interstate cases. It applies to emergency situations. It alerts judges to risk factors. One of the things our study showed when we were drafting UCAPA is that a lot of judges didn't take threats of abduction seriously. They thought, oh, these are just high conflict parents. They're just blowing off steam. Nothing's going to happen. And they didn't do anything when they could have done something. And then kids are gone for 4 or 5 years or forever. And it allows you to modify an existing decree to add protection orders into the decree. So what's the jurisdiction? UCCJEA. So you're still using your basic jurisdiction. There is an emergency if there is a credible risk of abduction. Credible means you're going to have to file, and when I get to the petition, it's a verified petition, and you're going to have to make allegations of facts as to what it is that gives you a credible risk of abduction, and that will go to the factors. If emergency jurisdiction is used and you've picked the kid up in another state, for example, Kansas, we have a Kansas couple. Our nearest airport is in Kansas City, Missouri. Okay, so if you live in Kansas City, Kansas, or Johnson County, Kansas, you may be filing an action in the court in Johnson County for custody. Parent may be at the airport in Jackson County, Missouri, because that's where the airport is. You can get an emergency order in Jackson County, Missouri to pick up the kid right then. And then after the emergency pickup, you send the case back to Johnson County where the custody order is pending. So this doesn't do any violence to our general jurisdictional bases under UCCJEA. It just gives a tool to protect kids. Who can seek relief? The judge, sua sponte. A judge hearing a case and who is afraid that one of the parents might abduct can impose these kind of protections on his or her own motion. There was a recent case just this year where a father tried to argue that the judge should have done that, but the mother, all she wanted was to get the passport for the kid from the father to go to the funeral of her grandmother in Poland. And the court found there was no basis under UCAPA because there was no credible threat of abduction. Mother had a job here, kid was here, dad was here. Nobody was threatening to abduct. She wanted 2 weeks to go to a funeral in Poland for her grandmother. And so the court found no basis for sua sponte. So just because you allege that there might be a basis doesn't mean there is if you have no facts to support it. A party to a child custody determination a person or entity entitled to seek a custody determination. This is one of the most important sections. This is where the pre-decree is allowed. So even if one parent hasn't filed the custody action, if you would be entitled to file a custody action as a parent, you can use UCAPA. A prosecutor or a public authority designated under the UCCJEA, and that's for the enforcement provisions. The petition has to be verified. If you have an existing order, attach it. If there are none, then you have to state the risk factors. And that's very important that the risk factors be stated. There can be confidentiality if there's domestic violence allegations, and that's one of the big concerns that some people have is, are we protecting victims of domestic violence? And the answer is yes. One of the questions that needs to be answered is whether either party to the proceeding has been arrested for a crime related to DV. And that may determine whether or not confidentiality goes into effect and how it's handled from there. Okay, there are 3 categories of risk factors, and I would like to thank Melissa for these. She summarized this once before. I heard her summarize them, and so I am borrowing them because we did them in a little different order. But basically, the 3 categories of risk factors are abduction planning behaviors of one of the parents. And this is the kind of threats, selling things, getting rid of all your stuff here, applying for passports and travel documents, taking refuge in your embassy, doing things that are kind of planning activities. The second are parents' ties to a foreign country, family language connections there and none here. And the third category is laws of other countries that are either not parties to the Hague or not compliant that would make it difficult to get a child back. So those are the 3 big categories. Now let's look at the specifics. The parental behavior category, threats to abduct and prior abduction. These 2 things actually have been shown by the researchers to be the 2 biggest factors. A parent who says you're never going to see this child again may mean it, and actually large numbers of them abduct. That's especially true if they have abducted in the past. And so something that you need to make sure, if somebody is threatened, that you have something in place to protect the child. Engaged in abduction planning activities, liquidating assets, getting travel documents, etc. Engaged in domestic violence or child abuse. 50% of abductions have involved child abuse. Now, not always in the way you might expect. Sometimes the abductor is the victim, but that doesn't mean that it's not an abduction. And so that needs to be considered. The risk factors for ties elsewhere. Lacks strong family, financial, or cultural ties here and has them somewhere else. This allows courts to consider the strength of a person's ties to this country or to another country. And if the person is working at a full-time job here and has been working there for 20 years, and there doesn't appear to be any problem with the job, may not be as serious as if the person is hopped from job to job, somewhat itinerant, works from home, transfers all assets to another country. A really good case to read is In re Axel Michael Sigmar. Although it was done under the Texas statute, which isn't quite UCAPA, it analyzes UCAPA and was probably one of the better cases out there for talking about that Mexico wasn't necessarily a compliant country, that they might not return the child, that father's ties there were substantially more than in the States. And it really does, it's a good example of a case using the factors where a judge actually went through the factors to make the findings of fact as to putting in prevention factors. Likely to go to a country that is non-Hague partner or non-compliant. poses risk to the child, human rights violations, restrictions on women. I will tell you, just like with Article 20 of the Hague Convention, this one I've not seen used. I've not seen, I don't know if Melissa or anyone else has, but I have not seen that one used yet. U.S. Department of State, current list of state sponsors of terrorism, and no U.S. diplomatic presence. And why is there no diplomatic presence? Because it's really hard to get help if you're in a country that you don't have an embassy or some contact that you can call to get help to get the kid back. There is a Section 7B exception to the risk factors, and this is the DV exception for the abductor who is a victim. And this is, in the hearing, the court shall consider evidence that the respondent believed in good faith that the conduct was necessary to avoid imminent harm to the child or respondent, or other evidence relevant to whether the respondent should be able to remove or retain the child. So if in fact there's a domestic violence order in place, if in fact there's been repeated violence and abuse or harm to the child, and you can show that you were taking the child to remove the child from a dangerous situation, then that is something the court will hear evidence on and make a determination as to whether that's a factor. Okay. What are the remedies? Let's say you found a factor or not. The first factor in Section 8 is what you can do to make your orders great. And we had several lawyers who were on the committee when we were drafting saying, I'm going to go back in and ask to change some of our orders that we've got on the books now, just to put in these things to make it clear, because they had a little bit too wishy-washy on specific visitation times. Put in the basis for the court's jurisdiction, and that should be the home state in most cases, that this is the home state of the child, where the child has lived with the parent for 6 months preceding the filing of the petition. The manner in which notice and opportunity to be heard were given. That's important not only for the United States, but in other countries, they want to make sure that the other parent had notice. Detailed description of custody and access rights, 7 o'clock Friday until 8 a.m. Monday morning, or whatever it may be, but specific times that are enforceable by law enforcement. If you're saying child was supposed to be here at 7 p.m., child's not here, so we don't end up with a horrible Castle Rock kind of situation where they enforce the order as written. A provision that violation of the order can result in civil or criminal penalties. My personal belief in drafting this was that isn't particularly helpful. It's only as helpful as the psychological benefit, but it's kind of like a PFA. PFAs don't stop bullets either, and they're only as effective as the people who are restrained by them act. And the fact that it says in bold letters, if you violate this order, you may be subject to criminal penalties, will deter some people. And that's the reason it's in here. It's in a couple of other state acts also. And identification of the child's habitual residence. Now, this may sound strange, but part of that is for the Hague Convention, Abduction Convention, and it's also for the 1996 convention that we have not yet signed. And so I don't want to get into too much detail. In most instances, the habitual residence will be the home state. In most instances, not all, but in most instances. And this is for international enforcement mainly. Okay, the considerations when you're looking at what kind of remedies to impose as protective orders, we have some caveats at the beginning to keep judges from going crazy. And not that any judge would, but first of all, you've got to balance that both parents have a right to a relationship with the child. And so that means you should impose the least restrictive means to prevent an abduction. So you need to take that into consideration. But you also need to take into consideration the legal and practical difficulties of return and the reasons for abduction. I'd like to give you one example from one of the women from Texas who was wanting us to write this legislation. She tried for over a year to get her judge to understand the extent to which her husband was planning to abduct the child. He had liquidated everything. He had gotten a passport. He had basically done all the planning activities and had money transferred overseas. And she finally got the Texas legislature to enact something similar to what UCAPA is now. But the judge imposed some pretty draconian supervised visitation, like only at a certain center. The mother on her own hired a bodyguard who carried a gun, who went with the father and child on all their visitations so that they could have a more normal relationship. And in some ways, I kind of thought that was a good thing. It showed some creativity. It showed that, yes, we do need supervised visitation. We don't want him heading to the airport, but having a bodyguard in a sweater and you know, cargo shorts kind of worked as a deterrent from the father abducting the child, but it also allowed the father and son to have a better relationship than they would have had if they'd had to sit together in a courtyard area and just talk to each other in that setting. So, you know, UCAPA doesn't prevent parties from coming up with creative solutions or suggesting it to the court in a given case. Okay, the considerations: age of child, potential harm from abduction. All children will be harmed from abduction. And if you need authority for that, I can get it from several sources. The legal and practical difficulties in return and the conduct of the parties. So what remedies? The obvious: travel restrictions. You may not leave the country without a court order or consent of the other parent. That is the number one that should be in almost all orders. They are now in many states for relocation, to keep parents from relocating to another state without a court order or permission of the parent. This is extending it a little more. Prohibitions on removal without written consent, court approval. Deposit of documents with the court. Courts aren't crazy about this. Some lawyers' offices will keep them, and some lawyers' offices don't want anything to do with them. And Melissa's going, no, don't give me a passport. But deposit of the documents so they can't get them. Now, I do want to be very transparent here. Kids with dual nationality, you can't keep the other parent from getting a passport in the other country. You can tell them not to do it, but that doesn't mean they can't get it done. But you can have at least the US passport deposited here and the other one probably deposited. Restrictions on getting the child a passport. The Department of State has wonderful instructions online on this. So you can keep the other parent from getting a passport. And protective restrictions as a prelude to exercising custody and visitation. And you can require things like supervised visitation, posting a bond. Education. I think one of the surprises for some of the researchers studying this on abduction is that educating parents as to the harm to their children long-term from abduction actually worked with a certain percentage of the population. So if lawyers representing clients who have other nationalities give handouts or explain to their clients how the child can be hurt from this, it might help prevent abductions. The warrant is a possibility, and I'll talk about that just in a minute. May be one of the most controversial, but it is one of the most effective, especially with cross-border states that have people going to airports in other states. And this is the part, Richard, that I was saying, grant any other relief available under state law. So it's a catch-all provision so that the judge and the parties can craft a remedy or get what they need in a particular case.
So Linda, let me stop you there because I'm going to tie this to a particular set of circumstances that I have seen recently, where a judge in a UCAPA petition, and not a UCCJ petition, but a UCAPA petition after a child was abducted to the United States, ordered the child to be returned back to the country of habitual residence. Now, under this catch-all phrase, it seems like it could be a remedy that might be available since a court is empowered under the UCCJA to enforce a foreign custody order. But the UCCJA has specific statutory requirements prior to enforcement of a foreign order, such as registration and notice. Now, absent registration and proper registration and notice, could a court under this provision order the child to be returned enforcing a foreign custody order?
That's a really good question. I think if I were representing the person who wanted the child returned, I would make them go ahead and register the order. I mean, that's what I would do to make sure it was registered under UCCJEA properly, because that takes away, I think, any doubt that it's a proper thing to do. But I do think the catch-all is broad enough to catch it because that's what they did. In the pre-decree cases, the case I mentioned from Kansas and North Carolina, there was no custody order in place. Dad was trying to get the kid back in Kansas because that's where the custody determination should be made. And he filed under UCAPA, and the judge in North Carolina said, yeah, this UCCJEA jurisdiction lies in Kansas. We're sending this kid back to Kansas. Yeah, so you can clearly do it.
On the other side, I would argue the particular provision of this says that any other relief available under state law. And if you don't provide the notice and you don't provide the registration, then it's not actually technically available under state law.
Well, that's what I'm saying. I would argue that I would make them register it so that there wouldn't be any question about it. I mean, good lawyering would mean you make sure there's no loophole for doing this.
Yeah, I think that one of the purposes of this program today is that I think in our experience, UCAPA is something that, there is scant case law with, relative to the UCCJA, certainly relative to the Hague Convention. So it's a body of law that either because lawyers are not as familiar with it, and so don't bring in as many cases pursuant to it, or, maybe there just isn't as much appellate practice with respect to these decisions.
Well, there's getting to be on UCCJEA. There have been like 6 enforcement appellate decisions in the last year or so. I mean, the UCCJEA they're starting to figure that one out, that you need to make sure you follow the registration procedure and if you want them enforced. But in the case under UCAPA, you weren't asking for enforcement of the registration order. What you were saying is basically that they have wrongfully taken the child and the child should be sent back.
Right.
So, it depends on the relief you're asking for too, as to whether or not it would apply. I only have one more slide and I'm going to let you guys go. And that is the warrant provision. There is the warrant provision in here. And when we drafted it, this was one of the most difficult provisions because this contemplates a pre-decree warrant. And usually you can't get a warrant unless you got an order. But this is based on a temporary only. And so it is ex parte. It does follow UCCJEA Section 3, and it says you have a hearing the next judicial day. So if you pick the kid up at the airport in Jackson County and say you're not getting on a plane with this child, and I've seen there've been cases where they've taken kid off the plane. That you have a hearing the next day so that, the parties can make their case as to whether or not you have relief or not under this. So it is a temporary deprivation, only enough to keep the kid from going, because once the plane takes off, you've lost to some extent, unless you can catch it at a connecting location. So you need to get them right then, if at all possible. And
Linda, sorry, go ahead, finish your thought.
Okay, no, I was just saying, if it is determined that you did the warrant for harassment purposes, you can get expenses and attorney's fees. So that's a deterrent to misusing the warrant provision, I think. So that's it. I have readings. Pat Hoff wrote an article about this in the Quarterly when it came out. I wrote an article about it when it came out. I wrote another article in Ron Brown's book. It's actually a more comprehensive article than just the act. It's the 2009 Family Lawyer. I can get people a copy if they want it. And I do have a copy of the one petition that we filed in Kansas. So
Thanks so much, Linda.
I'm done.
Linda, we have like 5 minutes, but we have several questions and I want to make sure I get to them. Are children's attorneys allowed to file, say, a motion or petition under UCAPA if there are open family court proceedings?
That's a really good question. I guess it would depend on if in the state they are considered parties to the action. The child is considered a party to the action, because a person who's entitled to a decree can bring it, but it would only be if the child were considered. In most divorce cases, the child is not considered a party. I don't know. What do you think, Lyle?
I go to the question, you always can file. What the judge will do with it, I think, depends on state law, and I can't answer that question. But
Right.
I think if you filed it and the judge was aware of issues, most judges I know are very concerned to do what's right, and I think they'd be deeply concerned by what was this all about.
I agree.
Thank you. So there was another question about Section 7B of UCAPA, the one that says, in the hearing on a petition under this act, the court shall consider any evidence that the respondent believed in good faith that the respondent's conduct was necessary to avoid imminent harm to the child. The question is, in regards to the 7B, is the court required to hold a hearing on the abducting parent's good faith belief?
If it says shall consider, and so if the issue is raised, I think the court has to hear the evidence. Now, the evidence may be insufficient if in fact there's no protective order, if it appears the parent is just doing it as a ploy to try, like some parents try and get protective orders first to get, custody, stability issues. But if in fact you have, like in one case that somebody called me about, the parent had killed the brother of the mother, and that's pretty radical. And that would give you some cause to believe they might be coming after you next. So I think it depends on your facts.
Right, maybe your judge as well.
Right, and your judge.
So we've talked all about the benefits of this particular act. Has anyone had any concerns raised about potential abuses of this act, such as parents who might just continue to consistently file motion after motion trying to harass the other parent? Or has anyone come across this or any other concerns that this group might want to think through?
I don't know of any. I do know that one case where the father was trying to keep the mother from going to the funeral in Poland. The judge pretty summarily said there's no credible threat of abduction. And I would think that these would be dismissed summarily if there's no credible threat.
I think from my aspect, as a legislator, I know there have been some father groups who had some concerns about it, thinking it would be used by the mother in a custodial situation just simply to block them. And I think there's enough protection written in the act that if that's the cause, I think a judge would quickly cut through that. And I, for one, don't like to make enemies out of my judge who's going to be hearing these cases down the road, because most of these, you don't hear them just once, you hear them a number of times. And I think the judge quickly learns who's playing games in it. So I think there's enough protection that you can put them in that in most cases, that type of nonsense will be stopped.
While we have a minute left, can I ask our speakers to tell us a little bit about the enactment process in other states, and if there has been any opposition to them, what the opposition has been about?
I can say domestic violence. the biggest, I think, I don't know, Lindsey can probably back me up on that, but I think the biggest concern is people are afraid that victims of domestic violence are going to be forced to stay with their abuser. But I think that we have, I mean, we tried really hard in building this in so that if it's a truly abusive situation, hopefully there will not be an issue. You know, we think it's enough to protect them because it says the judge shall hear evidence of a good faith belief. Now, the judge may not believe them because they may find it's bad faith, but the person at least has their day in court to say it was a good faith belief.
Have we ever seen a real world application of this along with the grave risk defense in a Hague Convention case? For example, you know, has someone had a hearing where they present evidence of abuse, spousal abuse, child abuse, where that they should not be prevented from traveling or from going to a foreign country, and perhaps that request was granted, or they went to a foreign country and they didn't return and they alleged grave risk of harm defense? I wonder if there's any case that had that interplay between the exception here and the Article 13b exception in a Hague Convention case, because that would be quite
that would be interesting.
Yeah,
Melissa, you might be more likely to know that answer. I have not seen the interplay of the two. I do know I have seen abuse as a grave risk of harm in several cases, but in those states, I don't think they have UCAPA. You know, the one person who would be able to answer that is probably Patricia Appy, because I know she has cited UCAPA, even though New Jersey has not enacted it. She has cited it in several cases, and I think at least a couple of them have been Hague cases. So that would be the best source for that, probably, is because Tricia really wanted that to be enacted in more states. She really liked it. She likes this act. So, and it's a really good act. It really does help protect children. And like I say, education is part of the key as to the harm to these kids that happens from long-term deprivation of contact with the other parent.
This is the only thing I've heard of. I had people make comment about fathers groups who feel like it could be, it hasn't been, but could be used by mothers to block them from seeing their children and having parent time with them. And my position, I find there are lobbying groups who want to justify their position. So they want to notify all their clients that they're doing great work to protect them. But my experience, I've told the people who've called me about it, read the act.
Yeah.
Read the act. Don't just react to it. Read the act. And I think there's enough protection in there for both ways because, as Linda said, an abducted child suffers extreme damage. And I think if we can prevent that, we really ought to.
I think that's a great message to end on for today. I want to thank everyone on our panel. You guys were great. I hope everyone got a lot out of this as much as I did. And I look forward to seeing everyone at our next event. And hopefully we can do more of these. I mean, I think we've really just scratched the surface on UCAPA issues and other uniform laws that affect families. And, you know, we definitely would be interested in putting on more programs like this. Education is key.
Thank you.
And please contact Richard or I if you have a further interest in UCAPA and New York's enactment of it. We're certainly exploring that. All right.
Tara, anything we need to do?
No, I think we're all set. If I may, can I promote upcoming programs of the international?
Of course.
All right, great. So for November 8th, we have a CLE on Afghanistan, the legal community's response. And then on November 9th, we have an ESG webinar on U.S. Brazilian perspectives, policies, and politics. And then another CLE on November 15th for the Yazidi genocide, aftermath for the Yazidi women, and the Family Law Committee's upcoming CLE, International Prenups and Postnups, a comparative New York and French perspective. Those are all upcoming programs. So I'd like to invite everyone to join the New York State Bar Association or its international section and its Family Law Committee. I've posted the link in the chat below. And I hope everyone has a great day. Thank you to all our speakers and to our moderators for a very wonderful and informative presentation. Thanks, everyone.
Thank you.
Thank you.